Yes.
Yes. Right. Can I take you back to 8062 and just hopefully try to explain what I was saying? This provision applies where the amount of credit is rendered excessive or, and we're talking about insufficient. Now, what that means is that previously the credit was sufficient, but it's been rendered insufficient because, in this case, an adjustment of the amount of tax payable in the United Kingdom. So essentially, the amount of tax payable in the United Kingdom has increased, which has rendered it insufficient, whereas previously it was sufficient. And the point I was making was, in this case, in year 2, increasing the amount of UK tax by bringing the dividend into tax, when there is also other income of 200, doesn't render the amount of the credit insufficient, because there was always income, plenty of income in the UK tax liability in year 2 that the credit could be set against. So it's not the increase in UK tax that has rendered it insufficient. What has happened is because of the carryback of management expenses and then the carry forward of DTR, the DTR then gets applied. That's the point I was making. So it's nothing to do with an adjustment to the amount of tax payable. It's due to some other events that have caused the carry forward. That's all I was saying. So in year 2, if you're making a claim in year 2, you can't make it under 8062 because there isn't, as I say, the amount of tax payable in the UK has not caused, the increase in that has not caused.
So the tax has gone, you accept that the tax has gone up in year 2?
It has, yes. And the position could be different if there was no other income and if there wasn't any other tax liability before.
So it occurred to me on the example, if you didn't have any interest income, this issue just wouldn't arise because there'd be no the DTR would carry on carrying forward.
Yes.
So
that's probably true. Assuming that the dividend income in year 2 was completely covered by.
Well, that's what the example
assumes. Yeah. Yes. So it's really applying 8062 in the rather unusual situation of the carry forward of DTR, which obviously doesn't exist under domestic law, or in our submission, not applying it. Can I, before I go on to issue B, which I can deal with pretty quickly, can I just go back? Sorry, there's one point I failed to deal with when we were dealing with issue 8, and it's simply the point in paragraph 228 of the Upper Tribunal decision. And it's this question about withholding tax, going back to my Lord's judgment in Prudential, and who was applied first.
Oh, yes.
And I quite take the point that my Lord made, that it wasn't decided finally in Prudential. This was a provisional view, etc. But it has been decided, of course, by the Upper Tribunal in paragraph 228. Yes. And in my submission, they've given cogent reasons in paragraph 228 why the withholding tax should be applied first. My learned friend didn't deal with any of those. He simply said, well, it wasn't decided in Prudential and the taxpayer should have a choice. But in my submission, you have to meet the points that they've made. They've made cogent points. That's a matter of principle. They've decided it should go first, and we would support that. We don't see how it can be a case of there being a choice.
Well, they make the point about the least impact. So we know, don't we, that the treatment of withholding tax is not affected by any breach of EU
law. Yes, it's not required under EU law. Yes. So that's Salomon, I think, as well, decided that, yeah.
I suppose this may not really be material at all, although I obviously did leave the question open, intended to. I probably went down the route I did, because intuitively, really, that seemed the most natural way to proceed. And that's not a very scientific argument.
Well,
on the other hand, some of these things are almost a matter of impression, and I'll kind of make the point, WHT is juridical level taxation being relieved, so you might think that should come before any
yes.
relief for unilateral relief. But again, not for any very scientific reason other than it sort of feels right.
Well, given that, I'm not saying you're making it up as you go along, but I mean, this is, we are dealing with a situation which UK law doesn't envisage. So I mean, an instinctive reaction. I think that's to some extent reflected in paragraph 228. That's a similar.
Slightly my impression. It was maybe none the worse for that.
Yes. Yeah.
The life of the law is experience, not logic.
Yes. That's
Justice Holmes.
But sometimes it's logic.
He said it more than a century ago, but it remains true.
Absolutely. The difficult part of law is deciding when it's logic and when it's I agree. So that's all I need to say about that. But I thought, sorry, I missed it when I was dealing with issue 8. Can I then turn to
Does
issue
that
B?
cover, have we covered B and E through that? Issue 3 and D, are they related to issue 8?
Well, I mean, issue B is simply whether the credit is capped at the UK tax.
Yeah.
That's what issue B is, and I think we've dealt with that.
Okay.
Simply to make the point, which is an introduction, I think, to issue C, which my then friend Mrs. Redax was going to deal with. That
Lucky her.
Yes. It was completely voluntary. I assure you. On issue B, just to look at what the Upper Tribunal said at the very end of what they said about issue B. Which is which is on paragraph 296. We are satisfied the FTT added law when it said the DTR credit is not capped and the rate of the UK rate of tax applied to the foreign dividend. Just to gloss that slightly, that would be the foreign dividend, if necessary, grossed up, of course. And the question of grossing up then is a question that has to be addressed in issue C. So I'll hand over. Are you okay there?
Good afternoon. Issue C is an issue on which HMRC appeal and which will be relevant to this case regardless of this court's decision on any other issues. So it arises regardless of any other points. And the reason for that is that the relevant claim for issue C is a claim which HMRC accepts is in time and covers the FNR. And that is in the supplementary bundle, tab 19, page 100. So that's a claim made by
Sorry, let's just have a look at that.
Yes, absolutely. So supplement.
Possibly raise your voice a little.
Yes, absolutely. So tab 19 in the supplementary bundle. Page 100.
Yep.
So that is a claim made by the lead appellant on this issue, Fidelity. It's made in March 2010, and it's a claim to DTR for underlying tax. And HMRC accept that would cover the FNR. So this is a valid claim brought within time. 2010 would cover the past 6 years under 8061, as it stood at that time. So because this claim exists, DTR credit will be given. Now the question is how that is done as a matter of computation, and issue C raises a question of law, a question of principle, which is to do with grossing up the dividend income which is to be brought into account. So the grossing up of dividends to be brought into account stems from section 795, and I won't take the court again to that. But essentially, what 795 says, if you are going to give DTR credit, you bring in the dividend income grossed up in respect of that underlying tax that or credit that you're going to give. So whenever DTR credit is allowed in respect of any dividend, that dividend is grossed up. And that's common ground between the parties. So where the problem appears is where management expenses come in and they cover the entirety of the dividend income. And therefore what you still give the DTR credit at the FNR, you still give it, but you carry it forward. You don't give it in year, so to speak. And what the FTT has done in this case, in those circumstances where you have management expenses in year one that cover the entirety of the income, and the FNR credit is to be carried forward, what the FTT decided is that you only bring into account the dividend income net of all tax. So net of withholding tax and net of FNR.
Sorry, bring into account in year one.
In year one, yes. So as to compute the management expenses that are needed to bring your taxable amount to zero. However, what the FTT also did is the FNR credit that they carried forward, that FNR credit was computed on the basis of the grossed up dividend income. So if I may explain that by way of an example. If one
Is this the example that's given in your skeleton argument?
No,
Or is it a
it's
different one?
It's a slightly different one because
Is there some reason to have a different example? Because personally, I found the example in the skeleton hard enough to follow, but at least it's there in front in black and white, and so one can try and get one's head around it.
I've chosen a different one because the rates of tax work better, and I've been thinking about.
All right, so you think you've got a better example? All right.
I think I do, but I'll try. So if a UK company receives dividend income of 200, that includes withholding tax. So 10 of that is withholding tax. Actually, the UK company only received 190. If there are no management expenses, both parties agree that the way to deal with that, where there is a valid claim, of course, is you take the 200, so grossed of withholding tax, you then gross that up for the FNR, and say the FNR here is 30%. So if the FNR here is 30%, you have gross income of 286. That's the gross income. And you bring that gross income into account, and what you do is you give withholding tax credit of 10 and FNR credit of 86. And you give that in year, and everyone agrees that's the way it works. So that's not an issue.
Sorry, but only up to the level of the UK tax.
Subject to the capping. But at the FTT level, the capping was decided against HMRC. So what the FTT did is gave the entirety of the FNR credit. But I agree. So for example, if the UK tax is 20%, 20% of 286, I believe it's about 54. So you would cap the 86 at 54 and you'd only give FNR credit of 54 because that's the amount of UK tax. 44, apologies. Because you deduct the withholding taxes. So that's what you would give. And everyone agrees that's fine. So the problem then arises if you have management expenses. So if you have management expenses that are big enough to cover all the income, what income do you bring into account? Is it the 190? Is it the 200? Or is it the 286? Where you don't have management expenses, we know is 286 that you bring into account. But where you have management expenses, the FTT said you bring in the 190. You only bring in 190, nothing more.
Yeah.
But the FNR credit, the way you calculate it, is by reference to 286. So your FNR credit is still 86.
Yeah, can I just pause? In relation to the withholding tax, the 10, when the tax returns would originally have been done, it would have been correct if you ignore the FNR credit to bring in 190.
Yes.
And the reason for that
Section 811.
is because of Section 811, and that says if you can't get a credit because you haven't got any tax to pay, it comes in as a deduction. Now, of course, in today's eyes, that's not, in a sense that we now know there is a credit, but would I correctly understand your starting point as not being to disturb the operation of Section 811 in relation to the withholding tax?
Absolutely. So that's issue 13. And we've conceded
That's part of issue.
13.
Oh, that is issue 13,
Yes.
is it?
Issue 13 is
okay.
where you have management expenses which cover the entirety of the dividend. What do you do with withholding tax? Well, we know withholding tax is not a EU law necessity. We give it as a matter of domestic law. And as a matter of domestic law, Section 811 tells us what to do with it. Namely, we deduct it. So we only bring into account the dividend net of withholding tax.
So
But
you
we
agree
agree.
that the starting point for this exercise, if you like, is 190?
Yes, dividend net of withholding tax. But then, because EU law requires the UK to give the double tax credit in respect of the FNR, we say that 190, so not the 200, the 190 should be grossed up for the FNR. So it is a slightly different computation than the one I've just explained. It's agreed in a year without management expenses.
In the skeleton where it was 90 grossed up to 129,
Yes,
here you say it's
190.
190 grossed up to a slightly different
272.
272.
Yes. So if we look at what the FTT did, just to confirm that what I've said is what the FTT decided, it's in paragraph 227 of the FTT judgment, which is at page 331 of the core bundle.
Sorry, could you just repeat the reference?
So it's paragraph 227 in the FTT's decision, which is at page 331
Thank you.
of the bundle. So here the FTT records the fact that the parties agree that where no management expenses exist, such as APE 2009, the dividend is grossed up both for withholding tax and for the FNR, because both of those credits are then given. But the FTT agrees with the appellants that such an approach is inconsistent with its further conclusions, and it says that it's only the net income, net of both withholding tax and the FNR, that should be brought into account. So that's the vice we identify in the reasoning of the FTT, and that is the issue against which we appeal. In the Upper Tribunal, HMRC advanced an alternative argument as well. So HMRC said, if the dividend is to be brought into charge net of tax, so if only 190 is to be brought into charge, then the way one should compute the FNR credit is not by grossing up at all. So you just apply, in my example, 30% of FNR to the 190, and that would give you a maximum of, I think, 38. More than 57, apologies. So that's 57. So what what HMRC found to be very difficult to accept is both that you bring in only 190 and you then calculate the FNR credit to be carried forward on the basis of the grossed up amount. So that's 86. But as a matter of principle, we believe our main case, not our alternative case, is the correct answer. Because that is a straightforward application of section 795, which says whenever you give credit in respect of dividend income, that dividend income is grossed up.
Well, to be clear, are you pursuing the alternative case if we're against you on the main case?
Yes.
Right.
So if you are against us on the main case, yes. Now, below, at all points, when the issue was discussed in the FTT and even now, my learned friend, the way it is being put by the taxpayer is that issue C is not open to HMRC because of HMRC's concession on issue 13 and because of the FTT's decision on issue 11. Now, of course, issue 11 has changed in the Upper Tribunal. So depending on what this court decides in relation of issue 11, that may or may not be a relevant consideration. But in terms of issue 13, what we say is that that's nothing to do with this issue. That is only to do with withholding tax, which is not, the credit for withholding tax is not carried forward, and therefore it is correct to bring into account the dividend net of withholding tax. But that doesn't necessarily then lead, as my contrary to what the taxpayers are saying, it doesn't then lead to the fact that the dividend should also be brought into account net of the foreign nominal rate. So just to finish on that, if I may refer to the taxpayers' skeleton argument in this court, obviously because we haven't heard their points on issue C, but just to address what they are saying, that's in the core bundle at page 106, paragraphs 42 and 55. Page 106 of the core bundle, that's the taxpayers' respondents' skeleton arguments in response to issues 3 and C on which HMRC appeal. And the relevant paragraphs start on page 106, it's 42, all the way down to 55. So if one looks at 47 and 48, for example, which deal with issue 13 and withholding tax, I've already answered that issue. This issue C is not to do with withholding tax and cannot be affected by issue 13, which is solely to do with the domestic legislation. What we're dealing with here is a completely separate situation, which is to do with the grossing up for the FNR. So that's not an answer to issue C. And then the taxpayers also make the point that section 811 applies. And what I say is it does, but only for withholding tax. So 811 doesn't apply in respect of the foreign nominal rate.
Well, to make that argument, you effectively need to say, I mean, I think I raised this possibly on day one. There's an element of how section 811 fits in with the rest of the code. The only overt cross-reference is section 811 says it's subject to section 795. So
Yes.
the answer you've just given is not screaming off the page.
Well, 795 tells us that if you do give double tax credit in respect of tax, you gross up the dividend income. And if you don't, we know section 811 applies because of that reference.
So you say because there's a cross-reference to 7952 in 811, go to 7952, it applies in any situation where you are claiming
Giving.
credit. If you are claiming credit, you have to gross up.
Yes.
And you say, as I understand it, it makes no difference. I mean, it's a links into
Yes.
one of the other issues. You are still claiming credit even though you can't use it in that year.
Yes.
You're claiming credit in year one.
Yes, and 795 renders itself to that interpretation because it says if credit is given in respect of dividend income, so not set against the dividend income in the year, nothing to do with that. So the wording doesn't pose a restriction. The wording of 795 doesn't automatically or necessarily lead to the application of
So-
811.
It may just be worth looking briefly at the wording of 7952. Page number.
So it's in tab 7, I will, page 52, I think.
So you say, well, credit does fall to be allowed in respect of this dividend. It
Yes,
doesn't matter that it's not being used in years.
that is our argument. So credit falls to be allowed. We know that because that's what EU law requires. We're going to allow that credit. Even though it can't be used that year, it will be used in a later year possibly. So credit falls to be allowed, and therefore the amount received shall be treated as increased. So the amount received shall be treated as grossed up with reference to that credit that is being given. And if I may go back to the taxpayer skeleton, paragraph 53, for example, refers to the fact that issue 11 somehow restricts the answer to this issue. Now, that was true perhaps in the FTT, where the taxpayers were successful on issue 11, but it was no longer true in the Upper Tribunal, where issue 11 was decided against the taxpayers. So that argument wouldn't necessarily stand here.
I'm not sure it necessarily does.
So
Well,
Issue
maybe,
11
maybe we don't need to go there, but it's not immediately obvious to me how it's.
well, my learned leader just addressed issue 11, which is namely you don't need to make a claim in year 1. That's when issue 11 arises. You don't need to make a claim in year 1, so we've lost issue 10. Issue 11 becomes relevant. You only need to make a claim in year 2. So in year 1, when you bring in your dividends into account, how do you know to gross up? Because you have no idea. You don't have a claim on the table, so to speak. Although we know these taxpayers did because we looked at that 2010 letter. So they did have a claim on the table, but they say it's irrelevance. If it's not needed, it's non-existent. It's an irrelevance. So they say if they're right about issue 11, you only need a claim in year 2. Then in year 1, how do you know to gross up? You just bring the net dividend in, and if you have a higher amount of FNR credit that so happens to be applicable to you in year 2, well,
Or you can potentially turn that argument round the other way.
well, I am saying that issue C is a clue that issue 11 can't be correct. The taxpayer's position on issue 11 can't be correct. We do say that. Because all these issues are so connected. So if the taxpayer's case is accepted on some of these, it leads to consequences which are quite extraordinary. But unless I can be of further assistance, that's all I have to say on issue C. If you are going to give credit at the FNR, which we have to, then the dividend should be brought into account grossed up. That is the...
Yes, I mean, you get in the taxpayer skeleton, they say, oh, well, that means management expenses are used more quickly. And I understand them to be saying that that's essentially not what Salonen and SC3
But that vice is completely cured by the carry forward of DTR in the full amount. So DTR credit at the FNR is calculated on the gross up amount that you brought in. And because it's calculated on the gross up amount that you brought in, next year, when you need that credit to be applied, you apply it in full.
Yeah, so you say,
There's no
well,
vice.
it's 6 1 half dozen the other, because what you carry forward is a larger amount,
Exactly.
reflecting the larger amount of management expenses used.
However, very important, what the FTT did, because they weren't interested in capping or anything else, is a complete mismatch. So the FTT brought, on my example, 190 in and carried forward 86 of FNR credit. Right, so that's the best of all worlds for the taxpayer. So they didn't carry forward FNR credit calculated on 190. They carried forward FNR credit calculated on the 286 on the grossed up dividend.
Yes, so the taxpayers need to address the apparent dichotomy between
The windfall, that there's a huge windfall if we're right. If the FTT was correct in bringing in only the net income and giving this FNR credit, that there's a huge windfall which doesn't seem at all compliant with what this court has to do to comply with EU law. It goes further than addressing any sort of economic double taxation. It's a windfall for the taxpayers. Thank you. Unless I can be of further assistance, those are my submissions on issue C.
Thank you.
That just leaves issue E. And I was going to say something at the very end about disposal. Issue E, from our point of view, is very straightforward. The issue seems to be whether, under the UFT rules, assuming there is some UFT to be applied, whether whether the UFT can be set against other income, not dividend income, in year.
Is this the carry across and possibly carry back?
Yes, certainly a carry across. I'm not sure it could be carry back as well.
Well, under the youth rules, you could carry back.
You can carry back, but all of it is you set it against dividend income.
Oh, in the carry back.
Yes,
So-
and in the year. Under 806D
So
4 and 5,
um,
it all relates to related or unrelated dividends. So this is simply a question of the application of the youth rules if we get that far. That's what the issue is about.
so this is 806D4.
Yes.
It's not 5, is it? Because that's all about withholding tax.
No, I think it's 4. But I think the UT identified all the rules, all the provisions that applied. It just said they all apply to dividends. 4, yeah.
So to be clear, under the youth rules, there was provision for some set off against other income. You say dividend income.
Dividend income, yes.
Some provision for carry back as well as carry forward.
Yes.
And obviously the Salonen solution is carry forward only, but against all income.
Against all income automatically.
So I think a point is being made about the
And the way we would look at it is that the EU law problem has been solved obviously by the Salonen and the FII Supreme Court 3. What the taxpayer can obviously quite fairly perhaps say is, if the result of all of the other issues is that there is UFT, they can apply it in the way that the statute tells them they can. Of course, we say there isn't for all the reasons we've had before, but we say the statute simply says that they can carry it back and forward in the year, but only against these various dividends that are not other income in the sense of non-dividend income.
So I know you would say that issue E follows issue 8. There isn't any.
It follows, yes.
There's no UFT in respect of FNR. As I understand it, the only additional point you're making is that if you're wrong on that, it's only dividend income.
which is what the
of the
statute, yes,
kind specified in the statute.
exactly.
And
You-
there's
you
certain types of dividend.
You just follow the statutory provisions, that's what we say. And this arose, and perhaps this comes on to what I'm going to say about disposal. Issue E, as with other issues, arose out of the decision of the First-tier Tribunal. Because what we asked the First-tier Tribunal to do, and they agreed to do, was they produced a draft decision answering all the various issues, which is 1 to 14, with some agreed. And then the idea was that the parties would go away and try and work out the consequences of all the different decisions, because as you can understand, they all interrelate and can have different consequences in relation to the actual closure notices and the actual amounts. When we did that, we discovered a number of other issues arose on the basis of the FTT's decision, and issue E was one of those. Issues A, B, C, D and E were the issues that arose after the draft judgment. And we asked the FTT to decide those, which it did, and then it applied those, and you'll see in its decision, it sets out the consequences of its decisions as a matter of pounds and shillings and pence in relation to all the closure notices. And on the basis of the FTT decision, of course, they directed closure notices in all the other cases because they held that they were in time for various reasons. Now, the Upper Tribunal, if I can just show you what the Upper Tribunal did, because of course the effect of their decision was different because they decided the issues differently. And what they did, if you just take the very last paragraph of the Upper Tribunal decision, first of all, I'm sorry, it's page 204, paragraph 315 in the Upper Tribunal decision. So they set aside the directions to issue closure notices because they had held they were all out of time. And then they realised that this would require a reworking of the figures because they decided a lot of the issues differently from the First-tier Tribunal. And what they did was they remitted it back in the normal way to the First-tier Tribunal to work out the consequences if the parties couldn't agree, which is a normal, in tax appeals is normally what happens. And what the parties agreed was that they wouldn't go through this process, which could be quite complicated, until the result of this appeal, at least, was determined, because it might be that there are changes here, and it would be a waste of everyone's time to do the calculations on one basis and then have to do them again on another basis subsequently.
I assume you're obviously dependent on our decision. To the extent we decide differently to the UT, we should be remitting. Is that what?
Well, even if you decide differently from the FTT, because we haven't had that remitter yet, so I think probably almost anything you decide, you should decide if you decide all the issues, and then make it clear that it should be remitted back to the FTT for it to be determined. Of course, in practice, most of the time when these remitters take place, as my lord will know, in practice what happens is the parties agree the result because they can go through the figures. That's most of the time. It's very rare for the FTT to actually have to determine these remitters on figures, calculations. But you have to have a backstop in case we can't agree.
Yes, and presumably whatever we say, if there's an application on either side to take the case one stage further, then you'll probably say put it on ice again.
We may well do that, yes, until
at least the application for permission.
Yes.
Where it ends up has been dealt with.
yes. But I think from your at the point of view of the court, I think the correct approach is to make sure it's being remitted back in the light of your judgment. Yeah. So that was all I had to say about disposal, and I think I spoke to my learned friend briefly about that, and I think he's probably in agreement that that's the sensible course of action. So unless there's anything else I can assist you with?
No, thank you very much.
All my submissions.
Very great.
Wakeful. With your Lordship's permission, please may I make my submissions in response and reply in the following order. Can I deal first, please, with my response to Learned Friend's submissions on issue 3, and then to deal with issue C, section 811 point, and then to make my reply on my appeal points. On issue 3, that's the claim for withholding tax shredder institutional growth. The starting point is that statutory provisions in Part 18, they do not draw any distinction between claims for relief under treaties on the one hand and claims for unilateral relief on the other. Similarly, those statutory provisions do not distinguish.
I'm sorry, is not section 790 in part 18?
The provisions concerning claims. The provisions, that's a substantive provision, but the provisions dealing with what you have to do to make a claim, I'm specifically looking at this stage. I've got submissions to make about the interaction of what section 790 does with what it is you have to do when you make a claim. That's why I emphasise it's a distinction between claims for relief. They distinguish different types of relief, that's absolutely right, but what we're interested is in what is it that you have to do to make a claim. And when it comes to claims, and I'll make this good, no distinction between claims for relief under treaties on the one hand, claims for unilateral relief on the other. Similarly, no distinction between claims for credit for withholding tax and claims for credit for other kinds of double taxation relief. And if one's looking for statutory provisions specifically concerning claims, we know that those provisions are very limited. We looked at section 788 sub 6. So claims that are not claims for credit in accordance with chapter 2, they're to be made to the board. But we are dealing with credit under chapter 2 in this case, so that this isn't the sort of claim that's required to be made to the board. Section 806, which gives us the 6-year time limit, that refers to any claim for an allowance under any arrangements by way of credit for foreign tax in respect of any income. So that's quite general in nature. And then para 54 of Schedule 18, that requires a claim for relief to be quantified. But we know from Class 8, and this is paragraphs 98 to 100, that what that requirement for a claim to be quantified actually means, and as I understand it, this is common ground on this appeal, is that the claim must be for any quantified amount, and that's in the authorities, page 1255. And no dispute that that requirement was met. So on issue 3, all that needs to happen in order for Schroeder's to have made a relevant claim is that it needs to have made a claim for double taxation relief. That's my submission. And if one looks, I'm sure the court recalls it, we can look up the form again. If you'd like to see it again, it's Supplementary Bundle tab 11. And it's page 78, but you'll recall it's box 61. Supplementary bundle, page 78. That box expressly contains a claim.
Sorry, page 78.
Yes, in the supplementary bundle, that's where I've got box 61 by what would be the second hole punch. I'm in supplementary bundle tab 11, starting at page 74, and I'm on page 78. And halfway down is 60 to 63, reliefs and deductions in terms of tax, and then it's 61. And in that box 61, there is expressly a claim for double taxation relief. As it happens, that claim is for just over £2,000. It's £2,022.94p. We know that that claim, in fact and in law, was too low in its amount. What the revenue does not dispute is that if a relevant claim has been made, when it comes to closing the inquiry, the revenue is bound to close the inquiry on a basis that's correct in law. And so if a claim is made, then that amount needs to be increased. And that, of course, must be right, not least because it reflects the important public interest in taxpayers paying the correct amount of tax. Learn Friend put his submissions in a number of different ways, and I'm going to address the various different ways in which it was put. But in my submission, none of the different ways in which he sought to characterise the matter get around revenue's central problem, which is that there is no statutory requirement that the claim must identify that it is for a particular type of double taxation relief. So taking this in stages, and as I say, there are a number of different ways in which it was put, and it was said at various points, well, this may not matter anyway, I am saying this, it doesn't matter if I'm wrong about this, etc. If I can just run through the different points and deal with them more or less as they came. First of all, suggested there was a difference between a claim for unilateral relief and a claim under double tax treaties. That was day 3, page 85. And that was where he did say, well, I don't think this point matters because the types of relief were different. I'll come on to deal with that as well. So the point being made was that the relief that was actually being claimed was relief under a treaty. Therefore, it couldn't be a claim for unilateral relief. In my submission, that misconstrues the statutory regime. There aren't different kinds of claim in that sense. What was required is a claim for double taxation relief. A claim under a treaty is a claim for double taxation relief, so a claim for double taxation relief has been made. And if we are looking at procedure, in my submission, it is not right to characterise the claim as being a claim made under a treaty or pursuant to a treaty. It's absolutely right that the claim is for the relief given in the treaty. That's right. But the treaty has to be brought into UK law, and as we discussed, that's section 788, orders in council. The claims procedure, and that's what we're concerned with, it's the claims procedure, that has to be the procedure that's laid down in the UK statute. So the procedure is not in the treaty. And that's why one has to be careful in talking about a claim for relief under a treaty. The treaty doesn't govern the making of claims. So that's point 1. Point 2, Learned Friend suggested in answer to my lady that you have to look at each dividend separately because you have to determine what the double taxation is of that dividend. That's day 3, page 76. So this is the dividend by dividend point. And in my submission, that analysis is not an answer. It does not follow that because substantively the relief requires consideration of the position on a dividend by dividend basis, that the claim is only for the dividends that have been considered in making up the figure in box 61. Nor in my submission can it be said that the claim is limited to the dividends set out in the schedule. We have to look at this at a higher level of abstraction, which is, have we got a claim to double taxation relief, and is that claim open? That's my first answer to that point. And my second...
So that seems to mean that you can make a claim for something that is substantively not due, and that amounts to a claim for something that substantively is due.
Because the revenue is going to inquire into the matter and work out what the position is.
The revenue won't necessarily.
No, but that's the world that we're that we're dealing with is where the revenue has inquired. The second point I'd make in relation to this line of argument is that
I'm still struggling to understand how you say there's a claim for relief under a treaty is the same as a claim to relief under Section 790, which is unilateral.
no, my lord, I'm not saying
Seem to me to be fundamentally
I'm not
different.
saying that it's the same. I'm saying that the relevant question is, has there been a claim for double taxation relief? I'm not saying they're the same thing, but I don't have to say that they're the same thing. This is all a function of what kind of claim needs to be made, and that is a function of the construction of the provisions. True it is, there are different sources of relief, treaties and unilateral relief, and true it is, there are different kinds of double taxation relief, both within treaties and within the scheme of unilateral relief, but we are dealing with what it is that has to be claimed. And that's a different question in my respectful submission.
Well, so can I be clear? When we look at the document in question, do you accept that on its face it is a claim for relief under the respective treaties?
My lord, as a matter of fact, that was what was being sought. That was the source of the relief, but it is also, and this is what's critical, a claim for double taxation relief. And so it's a claim.
I'm puzzled. So you accept that on its face, it's a claim for relief under the treaties. So is it your submission that as a matter of construction of the document, one can somehow interpret it as nevertheless a claim for unilateral relief?
My lord, what I'm saying is that what needed to be done was the making of a claim for double taxation relief. And
that seems not to be an answer to my question. So please can I put the question again? I believe you've accepted that on its face, the document is a claim for relief under the treaties. Is it your submission that as a matter of interpretation of the document, it can be interpreted as a claim for unilateral relief? And I think the answer is yes or no.
My lord, I'm going back up half a step. What I accepted was that as a matter of fact, what they were doing was claiming relief under the treaty. But what I'm saying is when you look at what that claim is in box 61, it is a claim for double taxation relief. That's what the statutory procedure contemplates.
Okay, so I will ask the question a third time, and if you don't give me an answer this time, I will have to assume it's because there is no answer. Do you say that as a matter of interpretation, the document can be interpreted as a claim to unilateral relief?
My lord, I'm not saying that. What I'm saying is that it doesn't matter because the statutory question comes in at a higher level of abstraction. That's my submission. Can I please deal with the point that it said, well, the claim is restricted to the particular dividends? With my submission, even if that is right, there has still been a claim for double taxation relief for those dividends. So there are dividends that are identified. They're identified in the schedule. And so a claim has been made in respect of those dividends.
Even ones where there is no withholding tax?
Yes, lady. Still a claim. It's in an amount of 0. Just a point of detail, and what my learned friend said may have been right in relation to this fund. I simply don't know. You'll recall looking at the schedule.
Where is the schedule?
It's page 82.
Okay. So you think it's a claim for double tax relief of any kind in relation to all of those dividends?
I say we don't get there because you have to look at this on a more global basis. But
when you say you don't get that, do you mean you do not turn to the schedule?
Yes. The schedule's not required. The only claim that needed to be made is the claim in box 61. And that is a claim for double taxation.
But how in relation to any income? Because one of the points made against you was that this could apply to any incomes, not
Well,
just dividends.
We're looking at a very specific circumstance where there is an inquiry and that's been held open.
Well, I don't think that, with respect, I don't think that answers the point. You're asking us to apply the rules, not just where there happens to have been an inquiry. You're asking us to interpret the statute in the way that you say is correct. So we need to properly understand the argument and its implications.
Can we take it in stages, my lady? Because if there's no inquiry and it's out of time to amend the return, then if you look at this return, if there was no inquiry, all they're going to get is the £2,000 in box 61, because it's never going to be inquired into, it's never going to be challenged, it's not going to be upset. So they would be stuck with that. What we're dealing with is a circumstance where there is an inquiry, and by agreement, and we know, if you look at the correspondence, that this followed Schroeder's writing to the revenue to say we don't think the treatment's right. And the way that this accounting period was dealt with was by the accounting period being left open. And the inquiry is in relation to dividends. So one would, my friend did, he raised the spectre at the end of his submissions on issue 3 of saying, well, there could be something completely different. I don't think he gave any
But
specific-
why not? Because on your argument, a claim carries with it a claim to anything.
Because we have to look at the claim and the inquiry.
But in your submission, any claim will do.
My lord, what keeps this open is the inquiry. And you have to look at what it is that's being looked at in the inquiry. So if the revenue, as they did here, they look into this claim, which we know is a claim.
So forgive me. Do I understand from that your submission is that what limits it is the inquiry?
That would be one thing, yes. And one would look factually.
But I'm struggling to understand. One goes in circles, because if what limits it is the scope of the inquiry, how can the revenue be inquiring into something that hasn't yet been claimed?
Well, they are inquiring into something that's been claimed. They're inquiring into the double taxation relief claim that's been made for these dividends. That's what the inquiry is. And that's why in my submissions, my friend gave the example.
But on your submission, this would, if a claim is enough, then it's just it brings in all other income.
Not necessarily, my lord.
Why not?
My lord, because what we're looking at is how it is that an inquiry is to be brought to an end, and so one has to look at what is within scope of that inquiry. If there's no connection at all to what was returned originally, so I think what my friend did was give the example of sort of 4 years later, there are some profits of a completely different nature. I'm not quite sure what it might be, but probably doesn't work very well with a fund. But suppose you have a company in receipt of dividends, and suppose it has, I don't know, some business profits in an overseas jurisdiction as well, and it simply forgot to claim DTR for those. That would have nothing to do either with the original claim or with the inquiry. And you might well say in that circumstance, well, I'm sorry, you can't bring that in. That's got nothing to do with what was with either what was originally claimed or with the subject matter of the inquiry.
And the scope of the inquiries here was presumably into claims to exemption.
Well, it didn't. No, the scope of the inquiry is into the return and includes these claims for double taxation relief, which are computed by reference to withholding tax.
Well, the revenue have had no reason to object to these particular entries.
No.
It must have opened inquiries, perhaps because of amendments to treat dividends as exempt, for example. It wouldn't, if it just had this return, it wouldn't have opened an inquiry, surely, because these are straightforward withholding tax.
Well, we could see what they said in the inquiry notice, I think, which is at page 86. And Ladyship is right to say it relates to the repayment claim that was made. That's
So
right.
yes, this may sound pernickety, but I think you said they were inquiring into the DTR claims. That's not quite right.
No, it's not quite right. It is right to say.
Can you help me, please? What's Petri Manningen
There
about?
was a case in the Court of Justice dealing with dividend credit, and is one of the cases that sparked what's now become the Prudential and the FII group litigation. It was a Finnish case. Manninen or Marninen, I think some people say. So it's certainly an inquiry that concerns the appropriate tax treatment of tax credit on foreign dividends, if we're looking at subject matter. That's why I understand why my lady is making the point that we have to test what the consequences of the construction are. But we also have to look at how it is that this particular case should be decided, and we look at the nature of the claim that's been made and the nature of the inquiry that's been opened. It certainly concerns tax treatment of credit on foreign dividends. Please can I deal with the third way in which my learned friend seeks to answer issue 3, which is his reliance on the fact that credit for underlying tax and withholding tax, they're separate credits. So this is dealing with the submission that this isn't a claim for underlying tax relief. That's page 83. And slightly earlier, page 81, reliance was placed on the point that the box for underlying rate relief, that hadn't been ticked. And my primary answer to that is that that analysis is a product of taking the wrong approach. Because we're simply asking, as a matter of construction, has there been a claim for double taxation relief? And it may be that I need to go slightly further and say, has there been a claim for double taxation relief in respect of dividends? And my fallback is a claim for double taxation relief in respect of these particular dividends. But if one of those is right, I will get home. Whether or not the underlying rate relief box has been ticked, there's still been a claim for double taxation relief. Underlying rate relief is the box 61 capital A, that's page 78. In the context of the legislation as enacted, that must be a reference to credit for tax paid. That's the credit in section 790 sub 4. 3 points on this. First of all, we're not interested in credit for tax paid. These claims are about the foreign nominal rate. Second,
And how does the reader of the document know that?
part of my complaint in this appeal is that this document does not contemplate claims at the foreign nominal rate. There are 2 problems with the UK provisions, and the first of those is that the UK provisions on their face denied relief to portfolio dividends for credit for tax paid. And I showed the court that right at the beginning of the opening. And so the Revenue's criticism here is a criticism of these claimants for not ticking the box for a relief which the UK provisions expressly denied. And that in my submission can't help the Revenue in resisting this claim. And the third point, and we know this from my Lord Launcelot Henderson's judgment in Prudential High Court, and I think I showed the court this in opening, the credit for tax paid is conceptually quite distinct to credit at the foreign nominal rate. That's Prudential High Court, paragraph 95, page 751 of the bundle. So in my submission, talking about underlying rate relief claim or relief for underlying tax in this context, it's a red herring that this form was not set up to deal with credit at the foreign nominal rate. I absolutely accept that. My submission is that that doesn't matter because all of these different types of double taxation relief are just that. They're all types of double taxation relief, and they're all englobed within the claim that is made in box 61 of the form. So my position is that the substantive entitlement to credit, or what the credit is as a matter of substance, one still has to ask, looking at the procedural provisions such as they are, what are the requirements as to what claim needs to be made? And looking at the procedural provisions, one cannot say, either looking at the legislation or indeed looking at this form, that there is any requirement to make some separate claim in order to access credit at the foreign nominal rate. There's nothing, for example, that says to
Let's explore that, because you made what seems to me to be a good point in the sense that the form clearly does not contemplate the possibility of a claim to credit at the FNR.
Yes.
Quite so. And we know why that's so, because UK law was non-compliant. Fine. But would you dispute that it would have been open to the taxpayer to have ticked the box for ULT?
61A, yes, but my point is that the box for ULT wouldn't get him an FNR credit anyway. See Prudential paragraph 95. They're conceptually quite distinct. They're different things.
But isn't it still an underlying rate relief claim?
Well, my lady, why? I'd ask rhetorically.
That's precisely what the FNR is. You can't say it's not an just look at the fact that what you're doing a conforming construction of is 790, and in particular the economic double taxation.
It's dealing with
of
economic
insurance.
double taxation, that's right, not
That is
juridical.
underlying.
Well, my lady, if one looks at statutory provisions, the only two things that were contemplated were credit for tax paid and withholding tax, and they're two different things. And we know, and I went through the history, the reason the FNR credit is there is to deal with the problem of the absence of reliefs lower down being passed up through the group.
Indeed, but we also know from Mr. Justice Henderson's judgment, subsequently approved, I believe, that you take the underlying credit at the higher, it's the dual credit, you take it at the higher of the FNR and the actual tax. The actual tax, you'd accept that's an underlying credit.
Yes, I would.
Why, if you're taking the FNR in the alternative, why wouldn't you describe that as underlying tax? Indeed, some of your other arguments in chapter 2 are all about saying there is taxpayer.
Well, my lady, in ground 2, what I'm saying is it's being treated in that way. That's right. But what I'm saying at this, when you look at this form, I do say that 61 cap A, it wouldn't have been apt in any event to claim credit at the FNR. And if one relies on that box as saying, well, that would have been the answer, that's what the taxpayer should have done, what actually ends up happening is the revenue ends up relying on the UK's own breach in that.
Is that so? Because what we now know, and of course this is with the benefit of 2020 hindsight, and nobody had that 2020 hindsight at the time, but what we now know is you could have ticked box 61A
Yes.
and put in the covering letter. This is the only box we can tick.
Yeah.
But please take this as a claim to credit at the FNR.
Yeah, if
And your answer to that is that's illegitimate because that's imposing upon the taxpayer the knowledge of what's to come when the Court of Justice decides.
that's one answer, and the other answer is Metal-Gesellschaft para 106, that the member state can't impose on the individual the requirement to seek the very thing that's denied on the face of the provisions. We're told in terms and in general terms that that's a breach of effectiveness. So that was what I was going to say about issue 3. It really comes down to, it's the level of abstraction at which one has to analyse the claim provision. And the very segmented view upon which the revenue relies, in my submission, it doesn't fit with the statutory provisions. It places upon the substantive provisions a weight that they won't bear. Can I deal next very briefly with issue C, which my friend Ms. Ruxandu addressed? I addressed this in my response skeleton, paragraphs 42 to 55. And I maintain those submissions. I think the court will recall, this was looking at Fidelity, 2007 to 2008 accounting period. Management expenses exceeded the profits in 07 and 08, so there was no work for double taxation relief to do. The starting point for this is that we know from FI Supreme Court 3 that in those circumstances there is no unlawful tax charge in the UK system in 07 and 08. That was the burden of the finding in paragraph 142 of FI Supreme Court 3 that there was nothing wrong with the rules on management expenses.
There was a paragraph in SC3 years.
I think it was 142.
Thank you.
And I make 3 points. The first is that HMRC's approach of looking to, if you like, disengage section 811, that is inconsistent with the revenues concession of issue 13, and I've set that out in paragraphs 47 to 49 in the skeleton. That's a procedural objection. And then the 2 substantive objections are these. First of all, the point of section 811 is that where no credit for foreign tax is allowable, then the income is treated as reduced by the foreign tax. So UK corporation tax is paid on the net dividend. And in 2007 and 2008, double taxation relief isn't available precisely because the management expenses exceed the profits. And so there's nothing to turn off section 811 in those circumstances. That's the first substantive point. And the second substantive point is that we say that if you bring the gross dividend into account, what you end up doing is using up management expenses. They're used up more quickly because they end up being set against foreign tax paid. You're going to have more tax paid on other income in later years. And so you end up with indirect taxation of the dividend income, and that's unlawful because it's contrary to Salomon. And it's not an answer in my submission to say, oh, well, you're carrying forward the double taxation relief itself. We've got to look at what's happening in 07 and 08. I think there was also a complaint about double counting, which I regret I didn't fully understand. We explain in paragraph 55 the taxpayer isn't claiming the double taxation relief twice. So in my submission, the first tier was right on issue C, and the Upper Tribunal was right to detect no error of law.
So you say the unlawfulness is in 07 and 08?
There's no unlawfulness in 07 and 08.
It would be unlawful if the revenue were right.
Oh, I'm so sorry, my lady. Yes, that's right. If the revenue were right, there would.
The unlawfulness would be in 07 and 08.
Yes, because you're using up the management expenses. That may, of course, get felt in a later year. That takes me to the reply on the taxpayer appeal points. I'll deal first with Grand 1, then turn to Grand 2. on ground one, please can I deal first with the issues of domestic law and then turn to the supervening EU law principles. So we're dealing under these various different issues with the validity of claims made before the conforming interpretation was established. First point is that the rules on claims, as they were drafted, they didn't anticipate that the UK would be found to be in breach of EU law, nor that there would be a conforming interpretation. And that, in my submission, is an important part of the context when it comes to interpreting those rules. And that's so whether I'm or not I'm right about the effect of what I describe as supervening EU principles. We have to look at these provisions in the statutory context, and the context is that claim provisions would anticipate a compliance system. It turns out that system is non-compliant and has had to be conformed. Point 2, paragraph 51, so this is dealing in particular with issue 2 and standard life. It's an important part of the revenues case that there's a separate code for claims. So we see that, for example, day 3, page 62. So in Milano Friend's submission, you can't use paragraph 51 if you've not made a claim, because he says not making a claim in a return is not a mistake in a return. Day 3, page 10. In my submission, that approach misconstrues paragraph 51 and the paragraph 51 system. Two main points on this. First of all, one starts with the taxpayer's belief. That's what gets you into paragraph 51. And we saw what Standard Life's belief was as a matter of subjective fact, because they set that out in the letter. And what's then required, paragraph 51 sub 2, authorities page 154 for the court's note, is that paragraph 51 sub 2 requires the revenue to inquire into the matter. Broad language. And they're to give the relief that is reasonable and just.
Yes, you need to read the prior words, such relief in respect of the mistake.
Yes, that's right. That's right. But my submission is that system can work without difficulty. Standard Life think they've made a mistake. They think they've overpaid tax. They bring this to the revenue's attention. We also have to look at this in a context where the credits, their effect, and we saw this in section 793, is that they reduce UK tax chargeable. And either way, whether it was a credit claim or a paragraph 51 claim, the end game was that Standard Life wanted its money back. And it's not an apt analysis of the mistake in my submission, and it's not a reasonable or just result for the revenue to say there's no mistake because there's no claim for credit. That's the first point. Second point is that it's a perfectly natural use of language to say that not making a claim is a mistake in a return. Not least because we know, and this is paragraph 57, which is authorities page 172 in volume 1, that where a claim can be made in a return, it must be made in a return. So if the mistake in the return is not including a claim, there shouldn't be any difficulty in simply concluding under paragraph 51 that tax has been overpaid because the necessary claim was not made in the return, and that constitutes a mistake. And then as to paragraph 51...
So you're looking at 57 too.
I was. Yes, I was.
Yeah, I mean, slightly by the by, the whole carry forward that we now have makes it not terribly clear whether we're looking at 57 or 58, perhaps.
Well,
You might say.
maybe so.
Yes.
I mean, that adds perhaps to the difficulty. But I'm just looking at the point of principle about what counts as a relevant mistake, because it's being put very starkly. It's saying, well, there's no mistake, because there's no mistake unless and until you've made a claim. And I'm saying, well, hang on a second, the provisions contemplate claims in returns. What's the problem with the absence of a claim being a relevant mistake? And also, I made a series of points in opening about the comparison with a High Court restitution claim, and the point was made to me, well, a restitution claim is different. I've submitted, well, not in any relevant way. I'm not going to go over all of that again. And I've submitted, well, the mistake can't change. I can see one's got to meet the conditions for relief in paragraph 51, but you've got to construe those conditions in the light of the background that I've identified. And then looking at paragraph 51 sub 3 sub B, which is the provision on which the Upper Tribunal decided the case against my clients, is saying, well, this is a mistake in a claim included in a return. They say, well, that's engaged, so you're not getting any relief. That's not right, because paragraph 50...
You need to deal with that. I think HMRC are wrong.
Well, if they're abandoning what's said in the Upper Tribunal, that's one. That's one. I thought it was still being maintained because it's in the skeleton, but I didn't assume it to have been
Please carry
given
on.
out.
It wasn't raised already.
If it's gone, that's great news. If it hasn't gone, I think my learned friend was going to say it hasn't gone.
Yeah, I'm not sure that we would say there was a mistake, there was a claim in the return, because there wasn't a claim in the return. I think we pointed out that it makes no sense to say that you can't make a claim in respect of a mistake in a return, a mistake in a claim in return, but you can if you haven't made the claim at all. That was our argument about the construction of the provision. It wasn't saying there was a claim and there was a mistake in it.
In which case it sounds like the Upper Tribunal's reasoning is being abandoned, in which case it may be that I don't need to deal with it. I hadn't understood it to be abandoned, and so and I'd simply be going to say that 51(3)(b) presupposes some claim was made. Just for completeness, this morning on issue 5 and on the fidelity claim, my friend did accept helpfully that fidelity claim was capable of being construed as a paragraph 51 claim. The court will recall that was the references to repayment, etc., just before 11 o'clock. And so that sort of validates, I suppose, what I was saying in opening. Issue 5 really is very much a replay of issue 2, particularly as a result of that acceptance. Point 3, claiming credit, if you have to claim credit. So under point 2, my submission is that the paragraph 51 claims that were made were good claims to recover the tax. Point 3, I'm now assuming that's wrong. I'm saying you have to find a claim for credit. It's important in that context that the rules are not prescriptive. No prescribed form. My learned friend helpfully agrees that the section number doesn't need to be given, nor does he say that any particular form of words needs to be used. And I'd repeat in this context the point I've already made, that the credit here is simply machinery. The credit reduces the tax chargeable. And the purpose of the interactions with the revenue here is to secure a repayment. And that's why in my submission, there is no problem just applying normal principles in construing the claim documents that we have to look at, and the relevant ones here are the standard life document and the fidelity document, as claims for credit. They're in relation to the very same dividends. They are to the same outcome. We know with hindsight that the reference to exemption is mistaken. the section 208 doesn't apply under the conforming interpretation. But we also know that errors can be corrected as part of a process of construction. And if we're saying that that conforming interpretation was always there, one must, in my submission, read these documents with that conforming interpretation in mind. And if one does that in my submission, one would appreciate that what in substance is being done, yes, under an inapt reference to inapplicable statutory provisions, but taking into account conforming interpretation, what's being done is a claim for sufficient credits to eliminate the D5 liability. That's how I say I get home applying normal principles of construction. If there needs to be a claim for credit. Point 4 is to deal with section 114, Taxes Management Act. And this is dealing with my friend Ms. Belgrano's submissions this morning. So one has to bear in mind where in the sequence of argument this issue arises. If one needs section 114, there's some kind of defect in the claim. So one needs to ask what that defect is. So the basis upon which one approaches 114, it may depend on the reason the court's against me on the earlier points I've been making. If we get that far, and then one asks, well, can section 114 remedy the defect? The principal two problems would be that the claim didn't say section 790 and the word credit wasn't used, because no other magic formula has been suggested for what should have been done in order to claim credits. Your Lordship has my submission, I won't go over this again, but the exemption to which reference was being made, that is substantively equivalent to the credit, and also that the amount claimed in the cases that we're looking at is the same. So there are, I think, 3 groups of issues. Learned from Ms. Belgrano made 4 submissions, but 1 and 2 probably go together, because the burden of her first 2 submissions was to say that section 114, it's official documents only, or putting it another way, it can't apply to documents generated and sent in by the taxpayer. That's the first point I've got to deal with. Looking at section 114, so this is volume 1 of the authorities, page 13. It's in a section of provisions headed up miscellaneous and supplemental, part 9. And the Taxes Management Act, that's dealing with actions that might be taken, yes, by the revenue, but also by taxpayers. For example, filing claims. So we talked, for example, about section 42, Schedule 1 Capital A this morning. So that's one important point of context. And the other important point of context is that this provision has to be interpreted in the light of the fact that we now have self-assessment.
Well, it hasn't been altered, has it, since self-assessment?
No, it hasn't. But, my lady, one doesn't fix the meaning with the meaning that it had in 1918 when it was first enacted. One has to look at what section 114 does in the light of the overall scheme as it stands today.
We're not concerned with construing the predecessor provision, but we are concerned with construing what Parliament enacted in 1970. Now, in 1970, self-assessment was not known, hadn't been thought of. So how can we construe what Parliament enacted in 1970 by reference to self-assessment?
Well, I'm not sure that approach to this is quite right. One has to look at this in the context of the TMA as a whole, and that includes the provisions in relation to self-assessment. I fully accept they come in late.
There is some authority, and I know there's passage in Venue on this about, I think it's called ambulatory theory or something like that, about interpreting statutes in the modern day and the
And
life.
ambulatory
Is that
always
what
always
you're
speaking.
referring to?
Yes, yes. So one has to take account, it cannot be right in my submission in 2025 to shut one's eyes to the fact that since
Yeah, but we seem to be muddling up different points. So, one is the question of an always speaking interpretation of what was enacted in 1970. Another is the fact that the 1970 Act was subsequently amended so as to bring in self-assessment. Now let's deal with the latter point first. So far as that is concerned, you can't possibly say that that has any bearing on the interpretation of Section 114, can you, when Section 114 was not amended?
change, that's true.
Right. So we discard the later amendments. Now, of course, we give a statute an always speaking interpretation. But what are the words in Section 114 which you say should be interpreted as applying to self-assessment?
In 114 sub 1, the word assessment and the words other proceeding. So you can read assessment as including self-assessment in the light of the introduction of that system. And other proceeding, we were told in Archer, generally taken to be a reference back to 113 sub 3, and that brings in, among other things, other documents required to be used in assessing, charging, collecting and levying tax. And I say simply that if you need to make a claim for credit, the document in which you make that claim.
Yeah, but you seem to be assuming what you're trying to prove here. Because the question at this stage of the argument is construing Section 114. Does it apply only to revenue documents, or does it also apply to taxpayer documents? And your argument is, well, we now know that there is such a thing as a self-assessment, and therefore this must apply to taxpayer documents. But how do you know that if you don't know about self-assessment?
I'm not saying and therefore, my lord, I'm simply saying that linguistically there's no difficulty in those concepts applying to self-assessment. And I regret, I didn't quite understand your lordship's question. If you don't know about self-assessment,
Yeah.
I don't understand why one wouldn't take into account the existence of self-assessment.
Because that's the very thing that you can't do. You can apply an always speaking interpretation to the words used. What you can't do is rely upon subsequent facts to construe the statute as originally enacted. And they are conceptually different.
Yeah, I'd respectfully say I'm not, at least I don't think, falling into that trap. I'm looking at how the words apply by reference to the system as we now know it.
Well, maybe I could put this question slightly more to the point, which is even in 1970, you would have had to make a claim, the taxpayer would have had to make a claim.
Indeed.
To double tax relief.
Indeed. And
So
those
it's
words.
arguable that self-assessment's a bit of a distraction here, and that you would need to say that even in 1970, a claim to double tax relief is one of the sorts of documents.
Maybe so, my lady. It does seem a strange way of looking to interpret the provision in 2025, but we certainly do know that even in 1970, claims for relief of this nature needed to be made, and one still has to ask as a matter of language, are those concepts capable of applying? The point that was made against me, this was under reference to paragraph 40 of the GLL case in the Upper Tribunal, was where you can't get within 113 sub 3 because a claim is optional. And that is too narrow in my submission.
What
This is
reference
my learned friend's submission this morning. She relied on paragraph 40 of GLL, which is in the authorities at page 1196. The point that was made there was to say a claim that a taxpayer makes is not a requirement. So it's not a document required to be used. And my response to that is that's too narrow an interpretation, because the premise of this...
Can I be clear what your submission is? Do I understand that you're submitting that the UT in GLL was wrong?
Yes,
Right.
in paragraph 40. I'm saying that if you are making a claim, the premise of this is that a section 790 claim is required. You might say if that condition is satisfied, if you are making a claim, then that's what you're required to do. So to the extent you need to identify a requirement, then we have that. So that was to deal with submissions 1 and 2. The third submission that was made was to say that the wrong kind of claim, or rather making the wrong kind of claim, that can't come within section 114. That was just before 11:30 this morning. And again, there was reliance there on the GLL case. The point I'd make on that is that that was dealing with a very different situation to this case. We saw there that the original claim was in respect of one particular taxpayer's interest in this fund. And what they tried to do was expand the claim to cover other profits that related to different taxpayers. What we've got in this case is very different. In this case, we have the correct claimant, the dividends are identified, and the effect of the claim would be the same. And then as to the Bath case, which was handed up to the court this morning, I'm not going to ask you to go back to it, but if the court looks at page 1429 at the letter B, you'll see that that's a case where the inspector got the facts wrong. The basis of the decision was that the inspector had misunderstood the information with which he'd been supplied. He later got some more information. He wanted to change the case that he was going to rely on. That's very different in my submission to this case, and it doesn't inform the
Seems to be
approach
a paradigm case of a mistake on one view.
Well, and that's my further submission, is that actually
So Bath and West is wrong.
is wrong. If I need to say it, it's very different, and if it's equivalent to this, it's wrong. Taxpayer here intended to assert their right to equivalent treatment. You can see the reference that was made, for example, by Standard Life to EU law. They thought they could do that by claiming exemption. If we get to section 114, that was wrong, and my submission is that that counts as a relevant mistake. Certainly it's a relevant defect or omission. And then submission 4, which my friend Ms. Belgrano made, was to say that the mistake, defect, or omission, that can't count because it was gross or fundamental, and reference was made to the Donaldson case. It was suggested under reference to Donaldson that section 114 could only cure defects of form and not of substance. The court will recall that point being made at around 11:20 under reference to the quotation that was set out in the Archer case. I simply say this, that was the position in Donaldson. What the Master of the Rolls was not, though, setting out in Donaldson was either a test or some sort of invariable rule. It's not saying it's only mistakes of form that can be covered. On the contrary, and the Court of Appeal made this observation in Archer. And it's for your note, it's paragraph 35 at page 1064, that Lord Dyson hadn't approached the question from some a priori categorization of what kind of mistakes were fundamental or gross. Instead, he concentrated on the nature and effect of the omission in the particular circumstances of the case. And so my friend is falling into the error of trying to do that meta classification. That's not the right approach. In the context of this case, the effect of what's being claimed is the same. Standard Life wants its repayment, and it wants it in the same amount as what it would have got had it claimed credit under Section 790. Bear in mind also, we are in fact dealing with a rule which does not require accurate quantification. See Class 8, paragraphs 98 to 100. Fifth and final point in relation to the pre-conforming interpretation claims. This is issue 9. And Milena Friend's submissions on Henderson at around 12 noon today. And you'll recall this is how paragraphs 15 and 31 interact with section 806 sub 2. And the submission Milena Friend made was simply to say, well, the amendment takes effect as part of the amendments made by the closure notice. And that's why he says there's no effect on tax payable. And my response to that is to say that that is depriving the amendment of any effect. And we know from paragraph 31 sub 4 that the amendment must take effect. What the revenues analysis is doing is actually depriving the taxpayer of any substance in his right to amend the return that he's already been given in paragraph 15. And that can't be right. When we look at paragraph 31, and we saw this in opening, what paragraph 31 is doing really is dealing with timing. It's suspending the effect on the self-assessment of the amendment.
Time limits, it's timing.
Timing, exactly. And so you have a claim made to assert EU law rights done within the applicable time limit. And as emerged in discussions with Milady, I think Milena Friend accepted that there's a disconnect between the outcome on issue 1 and the outcome on issue 9. And my submission is that's a further sign that the analysis has gone wrong on the revenues side. So those are my submissions on the domestic law aspects of ground 1 in reply. The second aspect of ground 1 that I need to deal with in reply is the EU law principles. Please can I make 6 points? First of all, the starting point is that EU law gives a higher level of protection than English law when it comes to legal certainty. In Milena Friend's submissions, and I think also in opening, the example's been canvassed a couple of times of a litigant who's simply unlucky in that developments in the law show that he chose the wrong remedy. Too bad, says English law as a matter of domestic law. My submission is that that is not a permissible conclusion when the remedy is within the scope of EU law. And that is because one has to take into account principles of equivalence, effectiveness, legal certainty, and effective judicial protection. And in particular, in this case, effectiveness and legal certainty, they operate together when it comes to procedural rules. And so one of the examples I think Milena Friend touched on in his submissions was the Court of Justice's judgment in Marks and Spencer. And in Marks and Spencer, as it happens, legal certainty was engaged because time limits had to be fixed in advance. and effectiveness was engaged because there needed to be transitional provisions. And it was a lack of foreseeability in relation to procedural rules, and in that case, the procedural rules were the rules on time limits. That was a breach of effectiveness. In this case, the problem is not so much or not just that there's a time limit that the claimants didn't know about. There was a lack of foreseeability in relation to the correct remedy itself. My learned friend was wrong to say in my submission that there were several effective remedies, and I'll deal with this in a little bit more detail in a second. My position is an effective remedy must be one that is foreseeable at the time. That's the result of the principles that underpin the cases which I showed the court in opening. I say this is what you get out of legal certainty and effective legal protection. So, for example, I showed the court in opening paragraph 51 of the Court of Justice's decision in Banco de Portugal. This is day 1, page 112 to 113. And it's set out by the First-tier Tribunal at paragraph 82 in its decision. That's core bundle, page 283. Principle of legal certainty. This is a matter of settled case law at the bottom of court page 283. That requires legislation to enable those concerned to know precisely the extent of the obligations imposed on them, and those persons must be able to ascertain unequivocally their rights and obligations and take steps accordingly. And then paragraph 57, which is quoted by the first tier halfway down court page 284, the effectiveness of the judicial review guaranteed by the first paragraph of Article 47 of the Charter requires inter alia that the person concerned is able to defend his or her rights in the best possible conditions. That's put in terms of legal certainty, but effective legal protection brings in similar requirements. That was the purpose of showing the court Gil San Juan, Bele, and Viciano. And it's notable that Milano Friend has made no submissions at all about the content of those cases. He simply says some different principle applies. Well, those principles are not engaged in this case, and I'll deal with that in a moment. But he's not disputed that the court can and indeed must consider those cases. And he's not disputed my submissions as to what they say. And we saw Gil San Juan, paragraph 31.
I still don't understand the relevance of Gil San Juan. Number one, you're not invoking conventional rights. Number two, it's not been applied by the Court of Justice. So how are we able to take it into account?
My lord, well, let me deal with the sources then. And you can see why you're able to, indeed why you must take it into account. If you look still within the first tier's decision, if one goes back to paragraph 74, and the reference to Unibet, core page 281 and at the top of 282. It's the principle of effective judicial protection. That's why it must be taken into account. That is a general principle of community law. It stems from the constitutional traditions common to the member states, enshrined in Article 6 and 13 of the Convention, and reaffirmed by Article 47 of the Charter. That's why, in my submission, not only can this court take that case into account, it must. It's not a requirement that I need to show Gil San Juan being applied by the CJU in some other case. The Charter, which its common ground is applicable because I showed your lordship the transitional provisions that make clear it
Yes,
continues
that's
to
not
apply.
disputed.
No, exactly. That brings in Articles 6 and 13. So when your lordship says you're not relying on...
I'm sorry, I don't understand the submission. What you've shown us is an authority which says effective judicial protection is a general principle of community law. So that being said, you don't even need the Charter.
Indeed.
Because it's a general principle of community law. And the court comments that it's reflected in the constitutional traditions common to the member states, B, the ECHR, and C, Article 47.
Yes.
But how does that lead to the conclusion that the content of that general principle of community law is affected by a decision of the Court of Justice of the European Court in Strasbourg in 2020?
Because when you look at the explanation in 76 in the first tier's decision, this is under reference to the explanations relating to the Charter of Fundamental Rights, core page 282, that the Convention is setting a minimum level of protection. EU law cannot give less than the protection in the Convention. That's why. There's a difference in ambit because Article 6 in a pure convention case is restricted to civil rights and obligations. That is not the case for EU law. But in terms of the rigour and the level of effective judicial protection, that explanation makes clear that the convention rights and their content is setting a minimum level recognised in EU law. That is why one looks at Gil San Juan and Belle. That is why those cases cannot simply be put to one side in my submission. And they are in my submission highly informative illustrations, Gil San Juan, Belle, and indeed Viciano, which is itself an ECJ case, as to the content of these general principles. Gil San Juan, we know that the right of access to a court is to be practical and effective. That's paragraph 31. Unforeseeability of a procedural requirement applied retrospectively, that can restrict access to the court to such an extent that the very essence of the right is infringed. And then Belle, I showed the court the passage in opening that showed that there was a breach because the system was not sufficiently clear or sufficiently attended by safeguards to prevent a misunderstanding as to the procedure for making use of the available remedies. And then Viciano showed the potential for legal uncertainty to give rise to a breach of effectiveness. I fully accept there wasn't a final finding in Viciano, but that was what was sent back to the Italian court to determine. And that, of course, was the result of divergent Italian court decisions. So effective legal protection and legal certainty, in my submission, they require the procedural rules to be foreseeable and certain. A litigant must be in a position to know in advance, when we're within the scope of EU law, what procedure he must follow. And on the Upper Tribunal's analysis, there would be a breach of those principles because the retroactive nature of the conforming interpretation would mean that the procedural steps these litigants have taken have been undermined. So it's not an answer in my submission to say that in a domestic context, a change in the law because of judicial decisions may operate adversely to a litigant. That does not respect these principles.
On this argument, the consequence is that the UK is in breach of UK law, of EU law.
Yes, and one has either to mould the claim provisions, or one has to give the taxpayers, as contemplated in Gil San Juan itself an opportunity to
So
amend
that
their
would lead to
claims.
the conclusion that there's some provision in UK law which either needs to be subject to a conforming
Yes.
interpretation or disapplied.
Yes.
So which provisions do you say that we need to apply a conforming interpretation to or disapply?
We will be looking at paragraph 51, section 790, section 806. And they either have to be moulded or they have to be interpreted so as to afford these litigants an opportunity now, in the light of this court's judgment, that will clarify the procedure to amend their claims. That's the possibility that's adverted to in Gil Sanois. Because one of the points the Strasbourg court makes there is there was no opportunity given to amend. So that's point one. One cannot put to one side these supervening principles. Point two, my friend's main answer to this was that there was an effective remedy, namely a common law claim. That isn't right. That's for two reasons. Let's look at Standard Life, first of all. Statutory claim goes in 2009. There was no certainty in 2009 as to whether a common law claim would be available for D5 tax. It is not an answer in my submission to say that that question was later answered with retroactive effect in FII Supreme Court 1.
But can you go so far as to say that it was certain in 2009 that there wasn't a common law claim?
No, but I don't have to go that far. Lord, I don't have to go that far. Standard Life was not in a position to defend its rights in the best condition.
If there was no certainty that there was no common law claim, there was nothing to stop Standard Life making a common
That's
law
not
claim.
the question, my lord, with respect.
Why not? If you're asking, did they have an effective remedy open to them? Yes, they had an effective remedy. It was open to them. They could have made the claim. They chose not to.
Well, the cases that I've shown the court show that there has to be clarity as to the remedy and the remedial route. That's Standard Life. For Fidelity in issue 5, we're looking at a claim made, I think, in 2013. By then, common law claims had been ousted from the 1st of April 2010, so Fidelity didn't even have that option. That's point one. And point two is that even if there is some other remedy elsewhere in the legal system, there needed, to comply with these principles, to be certainty about the statutory remedies too. The reason for that is that the statutory remedies, they are themselves San Giorgio remedies. Statutory remedies are capable of being used by a litigant to recover taxes levied in breach of EU law. And the concept of a San Giorgio claim is not limited to a common law claim. An example of that is a claim to recover overpaid VAT. Take Marks and Spencer, or the claim in the Littlewoods litigation. Those were claims to recover overpaid VAT under Section 80 of the VAT Act. They are San Giorgio claims. So the statutory remedies, they must comply with the requirements of EU law, including legal certainty and effective legal protection. That's the second reason why the common law claim in my submission is a red herring. Third point, Milano Friends sought to make something of this court's judgment in AXA. It's day 3, pages 44 to 48, relying in particular on paragraph 164. In my submission, AXA does not guide the answer in this case. I will leave to one side the permission to appeal application that's currently before the Supreme Court. If one just looks at this court's decision, the problem for the taxpayer in AXA was that the common law remedy had, in a way that was EU law compliant, been removed with effect from 1 April 2010. So unless AXA had brought its claim before 1 April 2010, it wasn't able to bring a common law claim. It would be confined to its statutory claims. That's why the court was asking what had been pleaded before 1 April 2010, and why the court took the view that if the cause of action hadn't been pleaded before 1 April 2010, then AXA couldn't succeed. And AXA, in that context of two problems, Some of the causes of action accrued only in 2017 and 2018. And the other problem was that the facts that needed to be relied on, which was a payment of tax in a later tax year, they were, in the court's view, different from the facts that had been pleaded prior to 1 April 2010. So AXA was not in difficulty as to whether or not to bring a High Court claim. And that doesn't help us in answering the problem in this case. Fourth is to deal with what my learned friend said about IDT, decision of this court. That was day 3, page 30. He took the court to IDT for the proposition that conforming interpretation is neutral as between taxpayer and revenue. 2 points. First of all, there was no issue in IDT as to what the right remedy was. There was no doubt that the taxpayer was properly before the court. IDT had appealed against the assessment. Point 2, and here I probably do need to ask the court just to turn up Lady Justice Arden's judgment. It's in Authorities tab 23, which is volume 1. And it's paragraph 110. And that's Lady Justice Arden addressing the principle of legal certainty. My point is simply this. It was, of course, it's page 254. Paragraph 110. It was not enough to satisfy legal certainty that conforming interpretation is known to be retrospective. Because if one reads the final 2 sentences in particular of paragraph 110, the court identified 2 factors that meant that legal certainty in that case was satisfied. The first was that the need to interpret in accordance with the directive was known, but also, and importantly, it was known that the supply of telecommunication services constitutes a taxable supply for the purposes of the 6th directive. It was both. And that leads to a more general point, which is that that conforming interpretation, that was concerned with ensuring that the taxpayer paid the right amount of tax. It's about a substantive dispute. It doesn't touch the procedural issues that we're talking about in this case. So that's the 4th point, dealing with IDT. And then the 5th point is, my friend said several times that the uncertainty came from EU law, in particular FII CJU2. That's not an apt characterization of what's going on here. The precise outcome of litigation is always unpredictable. The problem in this case arises because of the uncertainty as to what procedure should be used to challenge the breach, which we now know to be a prima facie breach because of the conforming interpretation, the breach of EU law. 6th and final point on this, just trying to draw these threads together. My submission is that the revenue is confusing. On the one hand, the substantive content of section 790 construed in the light of EU law. So what credits is a taxpayer entitled to, and therefore how much tax is the UK entitled to charge? That's one thing. It is quite a different thing to ask what is the procedure through which the taxpayer can give effect to his EU law rights. In Prudential High Court, there was no issue as to the correct procedure, and the court will recall I showed you paragraph 106 in Prudential High Court, paragraph 77 in Prudential Court of Appeal. It didn't make any real difference in that case. But more importantly, the conforming interpretation there was given in the context of considering Prudential's case on the merits. And the conforming interpretation dictated the amount of restitution to which the claimants were entitled. And that, of course, discharged the duty of ensuring that the claimants obtained a proper amount of restitution for breach of their EU law rights. Not too much, not too little. We are at a prior procedural stage, and the question is different. The question is, were the claims validly brought? And the court's duty under EU law in this context is to ensure that the procedural rules provided effective legal protection. And in my submission, that means that the claimants must have had an effective remedy that existed at that time and which was certain. So if the court applies a conforming interpretation which was given in the context of adjudication on the merits, with the result that claims that have been brought are invalidated, that doesn't comply either with the principle of legal certainty or the principle of effective legal protection. It denies the claimants effective judicial protection. And as I've submitted, that means that either the procedural requirements need to be moulded so as to enable the claims to succeed, or there must be an opportunity to amend. And that fits in my submission if one stands back and asks, what are these claimants actually claiming? They are claiming a repayment of unlawful tax. And they were right. So take Standard Life. They were right that the UK provisions were unlawful. And it cannot be right that despite having formed that view, having brought a claim within the time period applicable to that claim, that nonetheless the claimant is denied any relief because procedural rules are being rewritten with retroactive effect. That is not permissible.
And you say it's unjust, despite the fact that they had an alternative remedy in a common law claim open to them, which they could have brought and which would have succeeded, but they didn't bring it.
Yes, I do say that, and I've dealt with the common law claim. That was my submission about 15 minutes ago. I did address the common law claim.
And so it's the revenue's fault, or no, it's not the revenue's fault. On your submission, it's the United Kingdom's fault that the taxpayers didn't bring a claim that was open to them to bring and which would have succeeded.
My Lord, I've made the submission that first of all, there was no certainty about the common law claim, and secondly, that it is...
But he would have succeeded. You accept that?
Well, we know that now.
Yes.
Yes, we know that now. But I've made the submission that there was no certainty about that at the time, and I've made the submission as to why it is that the common law claim is a red herring, because there has to be certainty about the available statutory procedures. That was the submission I made about a quarter of an hour ago. There needs to be a real, practical, certain, and foreseeable remedy. And that remedy has to fulfill those conditions at the time that the claim is being brought, and that's a requirement of the supervening principles of EU law. So those are my submissions in reply on the EU principles.
Sorry, just going back, you mentioned in relation to common law claims, Fidelity making a claim in 2013. Is that the one that was handed on?
I believe so, yes. And I'm simply making the point, by then a common law claim wasn't an option.
But then by then we had CJEU 2.
That's true. Please can I feel I've got a few brief points to make on ground 2. We had CJU 2, we didn't have Prudential Chancery.
Yes, understood.
So ground 2, section 790 and how it fits with other provisions. I need to deal with what my learned friend said about my reliance on FII Court of Appeal 1 and the point on section 801 and blending. You'll recall I placed quite a bit of emphasis in opening on the question of technique and why it is that section 8...
2. Court of Appeal 2, I think.
Oh, I'm so sorry. Did I say 1? FI Court of Appeal 2. I think I did. I said 1. I'm very sorry. FI Court of Appeal 2 and the question of blending in the FII litigation. Because it was said, well, this was all just about applying the approach and machinery of Section 801, that was day 3, page 38. And the point I was making was that the conforming interpretation, it also triggered the blending provision, that was 801. And 801, like as it happens, Section 806, also used a concept of tax payable. And I used that to buttress my argument that when one recognises the credit at the foreign nominal rate, the credit at the foreign nominal rate is a credit in respect of tax payable. Now, the answer to say, well, the explanation of Section 801, that's just about applying the approach and machinery of Section 801, that doesn't work, because a court doesn't have the authority to apply the approach and machinery of another statutory provision unless that provision actually applies. We can't do judicial legislation, we're dealing with statutory interpretation. We've got to ask, in FII, what's the justification for applying Section 801? And if one has FII Court of Appeal 2, it's Authorities Volume 3, tab 37, and it's paragraph 113 where my Lord's approach is endorsed. The point that's made under the letter J.
Sorry, can you give me the paragraph again?
Paragraph 113,
Thank you.
page 951. I've got to look at the question in the context of the actual tax system, 4 lines below the letter J. And that actual tax system, that was binding as a matter of domestic law, and that has to be applied by the English courts subject only to any disapplication or conforming construction which may be needed in order to make it compliant with EU law. And just pausing on that paragraph, Section 801, this is not to do with what EU law requires, because we know, looking at the penultimate sentence of paragraph 54 of my Lord Sir Launcelot Henderson's judgment, that the Section 801 machinery, that was not itself required by EU law. The point is, just as in Prudential Court of Appeal, which I showed the court in opening, once the conforming interpretation was done, the other provisions applied according to their terms. That's why I say that it's critical to focus on that controlling concept in Section 790, which is then picked up later in other provisions in Part 18, and that concept is the concept of tax payable. And that's why the credit at the foreign nominal rate, it has to be a credit in respect of tax payable. Second point to deal with on this, my learned friend said that nothing was happening under the laws of any other territory, so you couldn't get within Section 806 sub 2. That doesn't answer my submission. My submission is that the notion of tax payable under the law of any other territory, that's a concept of UK law. It's the UK understanding of what comes within that concept. And then point 3 on 8062 in issue 6 is just to pick up the discussion at around 1225, that there was an element of self-perpetuating time limit, I think was how it was described. In my interpretation of 806 sub 2. I don't accept that. It's not simply about the taxpayer realising that he's not claimed enough credit. What this is that it's established that there's a difference in what the UK recognises as tax payable under the law of the other territory. And that comes in Prudential Supreme Court, or at the earliest in FI CJU 2. So it's not that this is some never-ending time limit. And then just briefly on issue 8, which is UFT, I simply observe that one has to keep very clearly separate the issues in relation to case A UFT and case B UFT. There's a danger of jumbling up those two issues. To be clear, issue 8 is not about whether a conforming interpretation needs to be given to the UFT provisions. I'm not saying that it needed to be UFT to comply with EU law. What I'm saying is that having done the conforming interpretation, which we know is a conforming interpretation to section 790, that gives, as this court held in Prudential, a specific and specifiable meaning to section 790. We then have to ask, do the UFT provisions apply in the light of that specific and specifiable meaning? And it's just like the blending of dividends in FII in section 801. 801 not required by EU law, but the 801 machinery still had to be applied. And then final point on issue 8, there's the point about the order in which the credits get taken. Do you net off the withholding tax first? The court will recall that. It came up at about 2:05. My objection to the Upper Tribunal's approach in paragraph 228 is simply this. There is no mechanism in the legislation that mandates that the withholding tax comes off first. And there's no basis for such a requirement to be read in. Just when I'm on issue 8, issue E is very closely linked with issue 8, and I understood Milana Friend to accept at 25:4 that if the youth provisions apply, we get what the youth provisions essentially say their effect is. And that's essentially what we ask for in paragraph 72 of the skeleton. My complaint about the Upper Tribunal was that they were wrong to say that you can't apply youth in year. My point is simply if you can get within the youth provisions, then they apply according to their terms. Can I just deal very briefly with issues 10 and 11, because I'm aware that I'm nearly out of time. On issue 10, the complaint is the unlawful charge in year 2. The effect of the revenues analysis in this case is that the Supreme Court's approach to the disapplication of UK provisions would actually mean that the taxpayers in these appeals do not have a remedy. And that would be despite the fact that the UK made no provision for this relief to be claimed. That can't be right. My submission is that what the Supreme Court was contemplating in FI Supreme Court 3 was that it's the automatic effect of EU law that achieves the carry forward. And what one looks for is when is it that there's an unlawful tax charge? And then just on issue 11, to answer my Lady Justice Falk's question, which I fear I paused on and then didn't come back to in opening. My position is that I can get home on issue 11 even if I fail on issue 10. The point is that section 806 sub 2 gives a new entitlement to make a claim. So if it applies, it does not require some prior claim to be made. And then just to confirm, Milana Friend made the point about disposal and what this court might do, and certainly for our part, given what the Upper Tribunal did in terms of sending the application of the rulings at the appellate stage back to the First-tier Tribunal to deal with that, to us that seems sensible. That there may be some discussion that the parties need to have in the light of the court's judgment, but at this stage...
Well, at any rate, nobody's suggesting that we should do the calculations, which is good news.
Exactly right, Lord. My Lord, that is my reply.
Very good. Thank you all for your submissions. Well, you've given us a lot to think about, and therefore you will not be surprised to hear that we won't be giving judgment now. Judgment will be reserved, and as you're well aware, the practice in this court is that you will get a draft when it's ready, and don't hold your breath on that because there are a lot of issues to determine. The draft will arrive under an embargo, which is to be strictly observed. And the purpose of that, as I'm sure you all appreciate, is twofold. Purpose number one is to enable you to correct our typographical errors and wrong dates and things of that nature, not to re-argue the case. Purpose number two is so that you can attempt to agree a consequential order if you possibly can. If you can't agree a consequential order, then please put in brief written submissions and we will decide the matter on paper. After that's all been done, the public version of the judgment will be handed down electronically with no need for any further attendance. Thank you again.
Well done. Well done. You did well. There's no no problems. Yeah, another mic. I really could bear to argue this case again.
Yeah, I've had it done over.
Thank you. Well done.
Yeah, of course.
Things to be recycled.
I think that's fine, yes, as long as there's space. Oh, please, may I have? Oh, yes.
Thank you very much.
So there isn't no problem. Indeed. My goodness. I was getting worried. Unfortunately not. Let's just back to you. That is it.
Brilliant.
Thanks very much. Barbara.
Legacy, God, you just claim that.
Sarah, are you going straight? I've got to grab my laptop and I'm on a timer. He says I come later than everyone, and
You're picking him up.
he says
now.
I stay there crying. He does it on purpose, I'm sure. It's great, they keep them till 6.
Yeah, you got them off at 8.
You picked them up at 6.
Yeah. Kindergarten.
I assume it's going to be
Sorry.
all
The cleaning is fine.
I can see that.
She stayed with us while we cleaned. We finished cleaning. Yeah.
Right. Everything back?
Yes,
Yeah,
please.
yeah.
Yes.
Oh, yeah.
Bye, Jonathan. As a team.
Yes, perfect, that's all right.
Yeah, that's gonna be a heavy one. The rest of them are quite light.
I take your judges.
Yep.
And I'll take Arnold's. So these are Arnold's. Oh, right. I'm doing these. No, she takes it with her. Did Henderson have his pencil case? Yeah. Wedged it in the trunk. One of the boxes. Yeah. Once it's at an angle. This weekend. Later.
can't pay